Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for episode 26 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we are covering cases decided between December 9th, 2020 and December 15th, 2020. Commonwealth versus Gboko is an appeal following a conviction for recklessly endangering another person and possessing an instrument of crime. In this case, the defendant was approached at a bus stop by two men who attempted to rob him. He attempted to fight back with a pocket knife. In doing so, he swung the knife and attacked an uninvolved bystander. The defendant was charged with aggravated assault and simple assault in addition to the other charges, but was acquitted of those charges at trial. At his trial, the defendant testified on his own behalf. In addition to his testimony, a stipulation was issued that he was a law-abiding and peaceful person. The defendant requested that the stipulation also include that he was truthful, but the judge declined to do so. This stipulation was admitted after defense counsel attempted to present several witnesses to address the defendant's good character. On appeal, the defendant claims the court erred by failing to include truthful in the stipulation. Generally, evidence of a person's character is not admissible to prove that on a particular occasion the person acted in accordance with that character. However, in a criminal case, a defendant may offer evidence of the defendant's pertinent trait, and if the evidence is admitted, the prosecution may offer evidence to rebut it. But specific evidence of truthful character is only admissible after the witness's character for truthfulness has been attacked. Truthfulness may also be admissible if relevant to the underlying offense. Here, the court found that truthfulness was not relevant to the underlying offense of recklessly endangering another person, and that the defendant's character for truthfulness was never attacked. Therefore, evidence of the character for truthfulness was inadmissible, and the trial court did not err in excluding it. Commonwealth versus Hawkins is an appeal following the denial of a Post-Conviction Relief Act petition. The defendant was arrested after police responded to his apartment following a complaint of domestic abuse. The police were let into the apartment by someone other than the defendant and observed the defendant and controlled substances as well as drug paraphernalia. It was the defendant's position that the person who let the police in did not reside in his apartment and therefore did not have authority to grant consent to enter the apartment. At trial, defense counsel did not file a motion to suppress. The defendant filed his PCRA petition claiming ineffective assistance of counsel. At the PCRA hearing, several witnesses were called. However, Ms. Domo, the woman who granted consent for the police to enter the apartment, was notably absent from the hearing. In a PCRA hearing for ineffective assistance of counsel, the attorney is presumed to be effective. The burden is on the defendant to prove that counsel was ineffective. In this case, in order to establish that counsel was ineffective, the defendant was required to prove that if his attorney had filed a motion to suppress, the Commonwealth would have been unable to prove that Ms. Domo validly consented to the entry and search. Because the defendant did not present Ms. Domo as a witness, there is no evidence to suggest that consent was not valid. In the absence of such evidence, the court cannot conclude that her consent was anything but valid. As such, the defendant cannot succeed on his ineffective assistance of counsel claim. On a secondary issue, the defendant claims that his warrantless arrest was improper because the police did not observe a recent injury on the complainant. Under the law, police have the right to immediately arrest without a warrant when there is a claim of domestic violence and recent physical injury. Here, the court finds that the term recent physical injury is not defined in the statute and that the term recent is highly dependent upon the context in which it is being used. In this case, the injury was 2 or 3 days old, and the court found that the delay in reporting in domestic cases is common, and therefore the observable black eye was still recent for purposes of the law. Commonwealth versus Frame is another appeal from the denial of a PCRA petition. In this case, the defendant was convicted of homicide in 1987. This PCRA petition was filed 31 years after his conviction became final. The defendant alleges that his PCRA petition meets an exception to the timeliness due to a decision in Williams v. Pennsylvania, which held that when a judge hearing the PCRA matter failed to recuse himself, even though at the time of the underlying case he was the district attorney involved in seeking the death penalty against the defendant, was a denial of due process. The defendant claims that his untimely PCRA meets the exception relating to a new constitutional right due to the Williams case. However, while the Williams case announced a new rule of constitutional law, it was procedural and not substantive, and therefore does not apply retroactively on collateral appeal. As the issue is not retroactive, the defendant in this case does not meet an exception for the timeliness and therefore is barred from relief. In our third and final PCRA case for the week, Commonwealth v. Friedland addresses right to counsel in a PCRA matter. Every person is entitled to counsel for a PCRA case. However, in this case, the defendant expressly stated that he did not want appointed counsel. He attended a grazier hearing where it was determined that he was waiving his right to counsel and that waiver was knowing, intelligent, and voluntary. He proceeded to litigate the case pro se, meaning without an attorney. Ultimately, the PCRA court determined his claims were without merit and the petition was dismissed. Only upon receiving that notice did the defendant request an attorney. His late request for counsel was denied and the defendant appealed. The court found that appointing counsel at that late stage of the case, after it was found that he knowingly and voluntarily waived his right to counsel and the court found no merit to his claims, would inappropriately provide him a second attempt at post-conviction relief. The court concluded that the PCRA court did not abuse its discretion in denying his request for counsel and he is therefore entitled to no relief. Thanks for joining us again this week. As always, the full text of each case can be found in the case notes. Please note that there will be no new episode next week as I will be taking a brief break for the Christmas holiday. Any cases announced will be covered in the next episode.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.